add a single venue per county. Your Honor, you can imagine an headquarter of a county, assuming that's where the exercise was taking place. The people who are at the ends of the county, how would they access to reach the venue and participate in the public participation exercise? This is contrary to actually what the Court of Appeal, the Supreme Court, rather, guidelines had provided for. The other point, Your Honor, according to the report, the nationwide public participation exercise at the constituency level gave 1 day notice on 4th of October 2024, the same date as the court ruling. Let me clarify here that the participation exercise was supposed to be on 4th of October 2024 for 1 day. But the ruling of Justice Moho, your brother, extended the participation for another 1 more day. Now that advertisement or publication also came in the same day when these exercises were supposed to finish. Now, what would happen that to the common mwananchi? Of course, confusion. Similarly, the orders which were given said that now the exercise should move from the county to the constituencies. Your Honor, what we noticed here is that in the constituencies, just talked about constituencies, never gave a specific place, address, where this exercise is supposed to take place. It's our submission that such an important exercise to remove the deputy president from office, who was elected by the majority of Kenyan in each gazetted polling station in the country, required a similar methodology and the participation to remove him from office. And certainly, the purported NGCDF offices advertised without prescribed venue address did not meet Justice Mwongo's court order to provide venues close to the people. In any case, the only venue close to the people is polling stations. The Honor, here, as I said earlier, even with the orders needed to have the exercise done at the constituency level. And the assumption here is that each constituency has these offices. But then what's the distance between where those offices are? They were not prescribed for somebody who's at the end of the corner of that constituency. By using highly legalistic language in the notices of public participation and in the circulated public view template, the assembly created a barrier to entry for the average mwananchi, reducing a constitutional right to a binary of support or oppose vote. The report indicates that primary information was hosted on the national television broadcast, KBC, print media, the parliamentary website, and social media, which was technologically biased and excluded vulnerable groups. In the BPI case, the court stated that relying heavily on technology ignores the reality that only small fraction of Kenyan as reliable internet access, and that technology has not been dispersed equitably to all Kenyans. Similarly, despite the Persons with Disability Act of 2025 requiring free sign language and braille in public forums, the Gachagua impeachment exercise failed to provide even the most basic reasonable accommodation for this 5% of the population with special needs regarding the exercise, which was unconstitutional as per Article 54. The report does not demonstrate that the public was provided with copies of the special motion, including the grounds in English, Kiswahili, prayer, and other communication channels and technology accessible to persons with disability, such as the Kenya Sign Language. In Turkana, as an example, as well as other marginalized regions where the report shows zero response via hand delivery and email, the report does not demonstrate whether it provided any mobile registration units or outreach as required by the PPI case to ensure nomadic communities were also involved. The notice, as I think it's been mentioned again, presents a one-sided script. It presents the public with the grounds for impeachment without the first petitioner's response. This was not a search for truth. It was an exercise in prejudice. By suppressing the petitioner's side of the story, the state violated its rights to fair hearing and public's right to make an informed decision under Article 47 and 50 respectively. And this is found in our submissions, page 48 and paragraph 107. One submit that since the reasonableness of the notice is to be determined on case-by-case basis, the adequacy of notice in the present impeachment process can be tested against the scale of electoral mandate it seeks to overturn. This is found also in our submissions, page 47 and paragraph 104. In 2022 Kenyan general election, the presidential mandate was exercised by approximately 14.3 million voters out of about 22.1 million registered voters nationwide, reflecting a wide democratic participation. Out of those who cast valid votes, roughly 7.1 million supported the ticket of William Ruto and Rigathi Gachagua, thereby conferring upon them the constitutional mandate to govern. This mandate was granted by voters decentralized across the 290 constituencies and dispersed across at least 24 counties in accordance with the constitutional requirements. That is also in our submission, page 4 and paragraph 2. Therefore, by contrast, a constitutionality compliant impeachment process ought to demonstrate that the public participation notices reached a substantial and representative proportion of that electorate. In the present case, the notice issued reached only a negligible fraction of the electorate, attributed to short times, limited publication channels, and accessibility to forums, which processes clearly falls short of the constitutional standards. And of course, my learned friend Tom Macharia has mentioned that this is evidenced by the alleged 200,000 plus viewers in the National Assembly report, which constitutes about 0.14% of the vote that mandated their win. Your Honor, statistically, of course, it sums up to a 0%. If it was a medical test, it will show negative results. There were only 11 memoranda that were presented to Parliament. Your Honor, and again, this I think has been said, I won't repeat it. This begs the question whether the National Assembly is suggesting that the sovereign will of 22.1 million registered voters in the nation is carried in the pockets of the 200 plus individuals who allegedly participated in the exercise. Your Honor, as you retire, you will find that the National Assembly's failure to issue reasonable notices contributed to the dismal performances in the public participation exercise, which cannot be taken to proportionately hold the views of the majority who voted the President and Deputy President into office. I also dare to say that the mode of the instruments that were used to collect information, the template instruments used in the public participation exercise lacked clarity, thus ambiguous, contrary to the Supreme Court guidelines. The various template instruments to collect data from the public participation exercise failed verification and identifiability test. And of course, we've mentioned that initially, which I think is a point to note, they were the first templates that did not have provision for identification. Then later, they were replaced. But we don't know the forms that were already in the public, what happened with them? Did they collect data? Is that data part of what was collected and reviewed? That information we don't know. Parliament equally did not state clearly how they were verifying the information they got from the public. Finally, let me just finish now. I wish, just to draw to your attention, this was your ruling here in this court, in the same case of Gachagua. Gachagua and 40 others, versus the Speaker of the National Assembly, and 15 others. 224 KEH 13473. This is what you stated. The impeachment case exemplifies the dilemma faced by the judiciary when handling cases that straddle the line between legal and political domains. There is no doubt that many are watching to see how the court will navigate this delicate issue, one that has significant implication for the doctrine of separation of power. Your Honors, the eyes of the nation are indeed upon this court. We echo your sentiments in paragraph 101, which reminds us that the people of Kenya fought for a transition away from marginalized judiciary. They envisioned a new order where government excesses are checked and where no harm of government operated beyond scrutiny. If the standard of public participation is allowed to fall as low as it did in this case, characterized by unverified templates, digital exclusion, and binary trap, then the Constitution promise of the will of the people becomes a dead letter. Thank you, Your Honors, for the opportunity to address you.
Thank you.
Good afternoon, my lords and my lady. I rise to highlight issue for determination E.
Your name, please.
My name is Echesa Willis. My lords and my lady, I do rise to address and highlight submissions with regard to the issue for determination number E, that is at page 11 of the issues for determination, as have been crystallized by the first petitioner. My lords and my lady, the substance of issue number E is to be found at page 51 of the first petitioner's submissions. And my lords, taking cue from the presiding judge's direction, I will not repeat what my learned colleague, Mr. Tom Masharia, has addressed the court with respect to Article 47 of the Constitution, as well as Article 50, sub-Article 1, with regard to the right to fair hearing as well as fair administrative action. My lord, I will, for purposes of guiding the court in appreciation of this issue for determination, I will draw the court's attention to the further amended petition, specifically averments contained at paragraph 97, as well as paragraph 106. My lord, that is the foundational essence of the issue for determination that I shall be highlighting. My lord, further to that, I do redirect the court's attention to the affidavit in support of the petition sworn by His Excellency Rigathi Gachagua. My lord, this is sworn on the 18th of October 2024. And my lords and my ladies, specific to the issue that I'm highlighting on, issue number E, my lords, I do direct the court's attention to the deposition made at paragraph 8H, that is at, it's not paginated. The next factual preposition, my lord, is the deposition made at paragraph 22. And lastly, I shall make reference to the supplementary affidavit of His Excellency Gachagua, sworn on the 27th of October 2024, specifically at paragraph 6. My lords and my lady, against the backdrop of what my learned colleagues that have made submissions ahead on the provisions of Article 47 as well as Article 50 sub-Article 1 that embody the requirement of fairness in decision-making before decision-making bodies, as has been submitted, my lord, the role of the Senate in this particular proceeding leading to the impugned impeachment, it has been submitted ably by my learned colleague, Mr. Masharia, that this was a quasi-judicial process. My Lord, submissions have been made with reference to, and in this particular, at this particular juncture, I do refer to the exhibit RG1. That is, my lords, the exhibit to the supporting affidavit that annexes exhibit number 1 that starts at page 566 through to 566 through to 583. My learned colleagues did indicate that there were pre-coalition agreements, and my lord, I would urge this court to take note of the specific provisions in these coalition agreements, specifically at page 588, which is specific with regard to the reservation of the position of the Speaker of the Senate. My lord, I refer to, this is the agreement between the Kenya Kwanza Alliance Coalition and the Pamoja Africa Alliance Party. Next, my lord, is page 567 that exhibits the coalition agreement between the United Democratic Alliance and the Amani National Congress Party and Ford Kenya Party. I will redirect the court's attentions to page 578. This is at paragraph, this is at article 21, subparagraph L and N. My lords and my lady, what those annexures, the purpose of that, of those annexures is to amplify the fact that the speakers of both the National Assembly as well as the Senate were direct beneficiaries to the pre-coalition agreements that were in place, and that which had been submitted by the first petitioner first before the National Assembly on the 8th of October 2024 in response and in his defense with respect to ground 1 that raised the charge on the so-called shareholding issue. My lords and my lady, the point to underscore in regard to those coalition agreements is that as early as the 8th of October 2024, when the first petitioner tendered his defense to the grounds that were purportedly moved by the National Assembly, it was clear that part of the evidence that the first petitioner was to present implicated or showed the involvement and the interest of the Speaker of the National Assembly. However, my lords and my lady, the Speaker of the National Assembly did not deem it fit to recuse himself, noting that the issue of his interest would play out in the defense of His Excellency Rigathi Gachagua. Further to this, when the motion was